and children themselves are unable to apply to the court because they are under the age of 18. However, the Domestic Violence Act allows for a parent or a guardian, legal parent, a legal guardian, to apply on their behalf. So once they are under the age of 18, the guardian or the parent can apply to the court for the protection order against the alleged abuser. And the parent would do the run-ins. They would take over the matter until it comes to court, and the court actually wants to hear from the minor themselves of the incident, so what actually took place on the alleged date and time. And at that particular time is when the minor would get involved to relate to the court and to give their side of the story, the allegation, to the court. But the actual process on the filing, the appearing in court, would be the parent or the legal guardian of the child.
Okay. Yeah. So there's also a question from Ms. Maureen Julian. She's asking, is there help available for victims outside of the protection order, as a protection order aggravates the abuser even more? Many women have lost their lives as a result.
Especially during the COVID-19.
Right, so no. The short answer is no. Your only relief to get some sort of protection in the legal domains would be the protection order under the Domestic Violence Act. It's the only thing that would really... Now, the court doesn't enforce orders. The court would give orders. The protection order is an order. To enforce the order, you would need to go through the proper channels, which would be the police officers. So again, as we explained on the last occasion, the protection order must be served on the respondent, and it must be left in the care in the closest police station. So if there's a breach of the protection order and you call the police station, the nearest police station, that is, they would not be unfamiliar with your matter. They would not be unfamiliar with the terms and conditions of the protection order, and you'll be able to respond on it. So your protection order is your best option, together with the Trans-Tobago Police Service. Now, we have heard it a lot of times in court where persons would say, well, ma'am, it's just a piece of paper and that won't stop. The most recent incident, it clearly showed that the protection order itself, the tangible, the physical copy of the protection order, no, it doesn't stop someone from walking into your house using a cutlass and chopping the person to death. But it gives some sort of protection with the use of Trans-Tobago Police Service. The court doesn't enforce the orders. The court gives the order for the police to enforce the order. So police officers too are also willing to help you more once you have a protection order. That doesn't mean they won't help you if you don't have a protection order, but it gives them certain powers when you have a protection order.
Enforce.
What powers would you say that gives them then?
Right. So the breach of a protection order, the police station, the nearest police station. Without a protection order, you may go to report an alleged assault, alleged threat. The police would have to do the investigations. They would have to see whether it's true or not. But with a protection order, you are not going to really report abusive, threatening language. You are not going to report assault. You are going to report a breach of the protection order. And you are breaching term 1, which is not to use physical violence against the applicant, or you are breaching term 2, not to use abusive, threatening language towards the applicant. So the police job now is to arrest you for the breach. So you can get some sort of immediate relief. You can call the police station, have a protection against this person, not to come within 50 feet of me. He's currently in front of my house, banging on the door. And the police is allowed to come and exercise their power for a breach of the protection order. Now, without the protection order, they could still come and warn him and talk to him. Yes, they could do that, but they have some more power. They have more power to arrest once there's a breach of the protection order.
So what you're saying is there are circumstances under which where someone might be in breach and they may still give him a warning. Give him or who actually a warning?
Well, again, all police officers are to operate with their discretion. That's something that we lack a lot of times in the police service. Your discretion. You have to use your discretion wisely based on the situation. Now, as I say, you have protection orders with it. Funny these days where not to use annoying language. So a term of a protection order is not to use annoying language. What is annoying language? We are a couple, we are always in some dispute.
Yeah.
I argue, you argue, we both arguing. That's annoying language. The police
It's
will come
annoying.
and arrest
Correct.
me for
Yeah.
breaching the protection order for using annoying language.
Yeah.
So again, it's based on the now the police officers are not to be judge, jury, and executioner. They can't come and make a decision on the spot. Well, no, he didn't breach the protection order, so we're not arresting him. There's a fine line to walk between the police using their discretion and the acting on the protection order itself.
Right. So now we have 𝗪𝗵𝘁𝗺𝗀 seeing or asking, what can a victim do if they reach out to the police for help and when the protection order is breached, but the police refuse, saying that the person is being difficult? Now, what is that about?
Oh, that we can't speak to that per se because they deal with the legal side of it. But if a police officer there's any suspicion of any favoritism or a police officer leaning to one side and not being fair and impartial in the situation, there are different avenues to deal with that in relation to a police officer, with relation to police complaints and so on for misbehavior or unreasonable behavior in relation to the police officer. But once a breach is reported, then the police officers have to act on that breach. There are different officers in the station, there are senior members in the police station that you can seek redress from. So that's a more, it's a non-legal issue in relation to the police officers.
Right.
So
I
I
think
would like to try here to ask a question in terms of, based on your experience, Mr. Daniel, would you say that the act itself has improved over the years to protect the victim? For instance, the 𝗪𝗺𝗁 orders act or something like that would actually help the victim to feel more safe,
Yes, well, there
more
was a recent
protected?
amendment in the 2020, which we would also touch on in today's webinar, where you would see the act more expanded what domestic violence is, due to the evolution in technology evolving every day. When the app was first created, there's Facebook, Twitter, Instagram, the emails, all those things were not something the parliament or the legislators at that time would have considered in drafting the act. So there were several amendments made in the 2020 amendment to the Domestic Violence Act. And one of the major amendment, you would see that parliaments are the people that create the laws within the land. And you would see they try to really give you a definition of what is emotional and physical abuse in relation to domestic violence. So let's deal with the 𝗪𝗺𝗁 first, and then we deal with the expansion of the law in relation to emotional and physical abuse. The 𝗪𝗺𝗁 order, when you get the term 𝗪𝗺𝗁, a domestic violence matter is to be dealt with immediately, promptly. So you may make an application to a magistrate court or a district court on Monday, and they may want to give you some relief because the situation is one that it needs urgent attention. So they give you a court date on Friday. Now you apply to Monday. Let's say the paperwork is processed. The respondent needs to be served with this application for the protection order at least 48 hours before the court hearing. But the court really acknowledges and sees the need for urgent hearing. So you apply for it Monday and they give you a date of hearing on Friday. It may not be sufficient time for the police officers to find the respondent and serve him with this summons, serve him with this application, notifying him that an application for protection order was made in court and you need to appear on Friday at 9 a.m. They may not have sufficient time to do that. Now, that doesn't stop the matter from being called on Friday and being heard on Friday. When the applicant for the protection order appears on Friday, she may relate, or he may relate to the court and say, well, ma'am, I applied for the protection order because every time my husband come home, he drunk and he beating me. My child father coming in front of the door, banging on my door, he come with a cutlass. When I come home and he don't cook something good, I don't cook something good, he cussing, he pelting over the pot, whatever the story may be. And the magistrate may look at the circumstances and say, well, the respondent wasn't served to come to today's hearing. But the domestic violence gives the magistrate the power or the judge to grant an ex parte order.